ಇವತ್ತಿನ ದಿವಸ 4ನೇ ದಿವಸ ಈ IPR ಮೇಲಿನ FDP ಪ್ರೋಗ್ರಾಮ್ ಅನ್ನ ನಮ್ಮ ಪ್ರೋಗ್ರಾಮ್ ಕನ್ವೀನರ್ ಆದಂತ ಪ್ರೊಫೆಸರ್ GN ಬಸವರಾಜಪ್ಪ ಸರ್ ಅವರು ನಡೆಸಿಕೊಡ್ಬೇಕಂತ ಅವರಲ್ಲಿ ಕೇಳ್ಕೊಳ್ತಾ ಇದ್ದೇನೆ. ಬಸವರಾಜಪ್ಪ ಸರ್,
ಸರ್
ಶುರು ಮಾಡಿ ಸರ್.
ಸರ್ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ?
ಕೇಳ್ತಾ ಇದೆ, ಶುರು ಮಾಡಿ.
ಆತ್ಮೀಯ ಅಧ್ಯಾಪಕ ಮಿತ್ರರೇ, ನಮ್ಮ ಕಾಲೇಜಿನ IQSC ವಿಭಾಗದ ವತಿಯಿಂದ ಆಯೋಜಿಸಿರುವ ಬೌದ್ಧಿಕ ಸ್ವತ್ತಿನ ಹಕ್ಕು ವಿಷಯ ಕುರಿತ FDP ಕಾರ್ಯಕ್ರಮದ 4ನೇ ದಿನಕ್ಕೆ ತಮ್ಮೆಲ್ಲರೂ ಕೂಡ ಹೃತ್ಪೂರ್ವಕವಾದ ಸ್ವಾಗತವನ್ನು ಕೋರ್ತಾ ತಮ್ಗೆಲ್ರಿಗೂ ಈ ದಿನದ ಬೆಳಗಿನ ಶುಭೋದಯಗಳು. ನಮ್ಮ ವಿದ್ಯಾಪೀಠದ ಅಧ್ಯಕ್ಷರಾದ ಪರಮ ಪೂಜ್ಯ ಡಾಕ್ಟರ್ ಶಿವಮೂರ್ತಿ ಮುರುಘಾ ಶರಣರನ್ನ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಅತ್ಯಂತ ಭಕ್ತಿಪೂರ್ವಕವಾಗಿ ನಾನು ಸ್ವಾಗತಿಸ್ತಾ ಇದ್ದೇನೆ. ಹಾಗೇನೆ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಕಾಪಿರೈಟ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇನ್ ಇಂಡಿಯಾ ವಿಷಯ ಕುರಿತು ಮಾತನಾಡುವವರು ಡಾಕ್ಟರ್ ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಹಿಟ್ಟಣಿಗೆ ಸರ್ ಅವರು. ಶ್ರೀಯುತರು ಹುಬ್ಬಳ್ಳಿಯ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದಾರೆ. ನಮ್ಮ ಮೇಲಿನ ವಿಶ್ವಾಸದಿಂದ ಶ್ರೀಯುತರು ಇವತ್ತು ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಉಪನ್ಯಾಸವನ್ನು ನೀಡೋದಿಕ್ಕೆ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಶ್ರೀ ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಹಿಟ್ಟಣಿಗೆ ಸರ್ ಅವರನ್ನ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅತ್ಯಂತ ಪ್ರೀತಿಯಿಂದ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಸ್ವಾಗತಿಸುತ್ತೇನೆ. ಸರ್ ಸ್ವಾಗತ. ಸರ್ ತಮಗೆ ಸ್ವಾಗತ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಅಂತೆಯೇ ನಮ್ಮ ವಿದ್ಯಾಪೀಠದ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಶ್ರೀ AJ ಪರಮಶಿವಯ್ಯ ಹಾಗೂ ಕಾರ್ಯನಿರ್ವಹಣಾ ಅಧಿಕಾರಿಗಳಾದ ಶ್ರೀ ದೊರೆಸ್ವಾಮಿ ಸರ್ ಇವರನ್ನು ಕೂಡ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ನಾನು ಹೃತ್ಪೂರ್ವಕವಾಗಿ ಸ್ವಾಗತಿಸ್ತೇನೆ. ಹಾಗೇನೆ ನಮ್ಮ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಚಾಲನೆಯನ್ನ ನೀಡ್ತಾ ಮಾರ್ಗದರ್ಶನ ನೀಡ್ತಾ ಬಂದಿರುವಂತ ನಮ್ಮ ಮಹಾವಿದ್ಯಾಲಯದ ಪ್ರಾಚಾರ್ಯರಾದ ಡಾಕ್ಟರ್ KC ರಮೇಶ್ ಸರ್ ಅವರನ್ನು ಕೂಡ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ನಾನು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅತ್ಯಂತ ಪ್ರೀತಿಯಿಂದ ನಾನು ಸ್ವಾಗತಿಸ್ತಾ ಇದ್ದೇನೆ. ಹಾಗೇನೆ IQSC ಸಂಯೋಜಕರಾದ ಡಾಕ್ಟರ್ ಹಾರ್ವೆ ಹೆಗಡಾಳ್ರವರನ್ನ, ಕಾಲೇಜಿನ ಎಲ್ಲ ಬೋಧಕೇತರ ವರ್ಗದವರನ್ನ, ಜೂಮ್ ಮೀಟಿಂಗ್ ನಲ್ಲಿ ಭಾಗವಹಿಸಿರುವ ಹಾಗೂ ಯೂಟ್ಯೂಬ್ನ ನೇರ ಪ್ರಸಾರದಲ್ಲಿ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನ ವೀಕ್ಷಿಸುತ್ತಿರುವ ನಾಡಿನ ಹಾಗೂ ಹೊರ ರಾಜ್ಯಗಳ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳು ಮತ್ತು ಕಾಲೇಜುಗಳ ಎಲ್ಲ ಪ್ರಾಧ್ಯಾಪಕ ಮಿತ್ರರು, ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಗೂ ನೆಚ್ಚಿನ ವಿದ್ಯಾರ್ಥಿ ಸ್ನೇಹಿತರನ್ನ ತಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ನಾನು ಆತ್ಮೀಯವಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸ್ವಾಗತಿಸ್ತಾ ಇದ್ದೇನೆ. ಡಾಕ್ಟರ್ ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಹಿಟ್ಟಣಿಗೆ ಸರ್ ಅವರನ್ನ ಮತ್ತೊಮ್ಮೆ ಆತ್ಮೀಯವಾಗಿ ಸ್ವಾಗತಿಸ್ತಾ, ಸರ್ ಇವತ್ತು ತಮ್ಮ ವಿಚಾರಗಳನ್ನ ತಾವು ಮಂಡಿಸಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಮತ್ತೊಮ್ಮೆ ವೈಯಕ್ತಿಕವಾಗಿಯೂ ಕೂಡ ವಿನಂತಿ ಮಾಡ್ಕೊಳ್ತೇನೆ. ಸರ್ ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಸರ್, ಪ್ಲೀಸ್ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ನನ್ನ ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇದೆ ಅಲ್ಲ ಸರ್?
ಕ್ಲಿಯರ್ ಇದೆ ಸರ್, ಕ್ಲಿಯರ್ ಇದೆ.
ಹೌದು ಸರ್, ಕ್ಲಿಯರ್ ಇದೆ, ಕ್ಲಿಯರ್ ಇದೆ.
ಸರ್ ಈಗ ನಂದು ಸ್ಲೈಡ್ ಶೇರ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಮಾಡಿ ಸರ್, ಮಾಡಿ ಸರ್.
ಹಲೋ ಸರ್. ಹಲೋ
ಹೇಳಿ ಸರ್.
ಶೇರ್ ಇದು ಸ್ಕ್ರೀನ್ ಮೇಲೆ ಬರ್ತಾ ಇದೆಯಾ ಸರ್?
ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸರ್, ಬರುತ್ತೆ ಸರ್. ಅಲವ್ ಆಗ್ತಾ ಇದೆ.
ಓಕೆ. ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಟು ಒನ್ ಅಂಡ್ ಆಲ್. ಎಲ್ಲರಿಗೂ ಮುಂಜಾನೆಯ ಶುಭಾಶಯಗಳು. ಸರ್ ಫಸ್ಟ್ ಸ್ಲೈಡ್ ಬಂತಾ ಸರ್?
ಇನ್ನೂ ಇಲ್ಲ ಸರ್, ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸರ್.
ಓಕೆ ಸರ್, ಶುರು ಮಾಡ್ಬೋದಲ್ಲ?
ಮಾಡಿ ಸರ್, ಶುರು ಮಾಡಿ. ನೆಟ್
ತಗೊಳ್ತದ ಅದು? ಓಕೆ ಅಂದ್ರೆ ನನಗೆ ಫಸ್ಟ್ ಸ್ಲೈಡ್ ಬಂದದಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗಬೇಕಷ್ಟೇ, ಜಸ್ಟ್ ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು. ಸರ್
ಈಗ ತಗೊಳ್ತಾ ಇದೆ ಸರ್, ನೆಟ್ ಸ್ಲೋ ಇದೆ.
ಸರಿ ಸರ್. ಈಗ ಸ್ಲೈಡ್ ಚೇಂಜ್ ಮಾಡೋದು ನನ್ನ ಕಡೆನೇ ಇರುತ್ತಲ್ಲ ಸರ್ ಕಂಟ್ರೋಲು?
ಹೌದು ಸರ್.
ಓಕೆ. ಎಸ್ ಸರ್. A very good morning to one and all. First, at the outset, with the devotional pranam to His Holiness Sivamurti Muruga Sharanaru, President SJM Vidyapith Chitradurga, and respected Sri AJ Paramashivaya, Secretary SJM Vidyapith Chitradurga, Sri M.G. Doreswamy, CEO, SJM Vidyapith Chitradurga, and respected Principal, Dr. K.C. Ramesh, and Professor G.N. Basavarajappa, convener of this particular online 1-week FDP on IPR, Dr. R.V. Hegdal, sir, IQAC coordinator, and my friend, and all the staff, teaching and non-teaching staff of the college, student friends, and my esteemed participants, my colleagues, a very good morning to one and all. First, let me tell you what is the importance of this particular subject, why one should study this particular subject. Sir, now it is okay, no? The slide is being shown. It is first slide.
First slide is updating, sir, but not showing.
Okay.
You go on, sir, you go on. It will be shown. Sir.
Okay, sir. Okay. Yes, sir. At the outset, let me thank the organizers for giving me this opportunity to share my views on the topic copyright protection in India. Now, you must be wondering as to why this subject is so important nowadays. It is so important because you may be knowing about the controversies that are, that we have seen in the past, in the 10 years, even before that. For example, the controversy relating to Three Idiot movie, that Amir Khan's movie based on Chetan Bhagat's novel. There was a controversy. The controversy relating to DDLJ movie, okay, and even a violation of copyrights of authors of various books, and some of the TV serials produced and telecasted based on certain works of the authors, okay, and particularly academic institutions like colleges, universities, research institutions, kind of plagiarism, what we are seeing nowadays, and particularly in the light of UGC regulations. Now UGC has made it very strict that if any research is found to be plagiarized, or if it crosses permitted limit, then there is a serious punishment on both the researcher and the guide also. So in the light of all these things, it becomes very much important for all of us to look this particular subject from this particular background. Why I am telling this? Because if we show our ignorance on this particular topic of copyright, plagiarism and all, then we may land in trouble. We may have to face legal consequences, legal action, even though we don't have any guilty intention or any kind of that kind of malified intention. So in order to be safe and in order to carry out our research without any fear, one should know this particular subject irrespective of the branch to which he belongs to, whether he is a law student, whether he belongs to natural science, social science, humanities, any other humanities. So that is the reason why I think this subject should be introduced even at the lower level of learning. Okay. Now let me tell you about the structure of my presentation, what I will be doing in this particular presentation. So as usual in the introduction, okay, then we will be trying to understand the concepts of property, ownership, right. These concepts one should know from the jurisprudential point of view, because this gives us a clear picture, a comprehensive picture. Okay, so that is the reason why one should have a proper understanding of these concepts. The third one is copyright. What do you mean by copyright actually? Okay, and why copyright protection is required. Okay, that is what I'll be dealing with. Then the subject matter of copyright. In other words, what can be a subject matter of copyright and what can be copyrighted. Okay, in other words. And after that, what cannot be copyrighted also we will be referring to. Okay. Then actually, under the law, what do you mean by this right actually? Copyright means what under the law? That is under the Indian Copyright Act. Okay, so then after knowing under the law, then what are the exceptions, okay, to this particular copyright protection, in the sense when it amounts to infringement, and then exception to this particular infringement. Okay, then after that I will be referring to issues involved, then finally the way forward. Okay, this is how I will be going through in this particular presentation. Hope, sir, now the screen is clear and I can continue. Okay, sir?
Okay, sir. Okay.
Yes, sir. Now screen is visible, no, sir?
Sir, ಒಂದ್ಸಲ ಅದನ್ನ ಆಫ್ ಮಾಡಿ ಆನ್ ಮಾಡಿ ಸರ್ ಸ್ಕ್ರೀನ್ ಇನ್ನೊಂದ್ಸಲ.
ಸ್ಕ್ರೀನ್ ವಿಸಿಬಲ್ ಆಗ್ಲಿಲ್ಲ ಸರ್?
ಆಗಿಲ್ಲ, ನಿಮ್ ಕಡೆಯಿಂದ ಒಂದ್ಸಲ ಆಫ್ ಮಾಡಿ ಆನ್ ಮಾಡಿ ಸರ್, ಆಗತ್ತೆ.
ಓಹೋ, ಓಕೆ ಸರ್.
ಒಂದ್ಸಲ ಆಫ್ ಮಾಡಿ ಮತ್ತೆ ಆನ್ ಮಾಡಿ ಸರ್. ನಿಮ್ಮಲ್ಲಿ ಸ್ಕ್ರೀನ್ ಇದೆಯಲ್ಲ ಸರ್?
ಹ್ಞೂ ಸರ್.
ಅದನ್ನ ಒಂದ್ಸಲ ಆಫ್ ಮಾಡಿ ಸರ್, ಮತ್ತೆ ಆನ್ ಮಾಡಿಬಿಡಿ.
ಓಕೆ ಸರ್, ಒಂದು ಮಿನಿಟ್ ಸರ್. ಅಂದ್ರೆ ಇನ್ನೊಂದು ಝೂಮ್ ಕ್ಯಾಮ್ರಾ ಅಲ್ಲ, ಅದು PPT ಅನ್ನು ಆಫ್ ಆನ್ ಮಾಡ್ಬೇಕಾ ಹೇಗೆ ಸರ್?
ಇಲ್ಲ ಸರ್, ನಿಮ್ಮಲ್ಲಿ ನಿಮ್ಮ ಮೊಬೈಲ್ ನಲ್ಲಿ ಆಫ್ ಮಾಡಿ ಆನ್ ಮಾಡಿಬಿಡಿ ಸರ್.
ಅಲ್ಲ, ನಾನು ಕೇಳೋದು ಈಗ ಝೂಮ್ ಆಪ್ ಅನ್ನೇ ಆನ್ ಆಫ್
ಅಲ್ಲ ಸರ್, ಸ್ಕ್ರೀನ್ ಶೇರಿಂಗ್ ಅಂತ ಇರುತ್ತೆ ನೋಡಿ, ಅಲ್ಲಿ ಅದನ್ನ ಆಫ್ ಮಾಡಿ ಆನ್ ಮಾಡಿಬಿಡಿ.
ಓಕೆ, ಅದನ್ನ ಓಕೆ ಸರ್. ಓಕೆ, ಎಸ್ ಸರ್, 1 ಮಿನಿಟ್ ಸರ್. ಇದು ಬರ್ತಾ ಇಲ್ಲ, ಇದು ಹಲೋ ಸರ್, just a minute sir, I'm trying. ಸ್ಟಾಪ್ ಶೇರ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಆನ್ ಮಾಡ್ಲಾ ಮತ್ತೆ?
ಸರ್, yes sir.
ಸ್ಟಾಪ್ ಶೇರ್ ಅಂದ್ಬಿಟ್ಟು, ಹಾ ಸರ್, ಈಗ ಮತ್ತೆ ಟ್ರೈ ಮಾಡ್ಲಾ? ಓಹೋ, ನೋ, ದಟ್ ಈಸ್ ನಾಟ್ ಸರ್, ದಿಸ್ ಬೇಡ. One minute sir, something. Sir, ಈಗ ನೋಡಿ sir, is it taking sir? Hello?
Yeah sir, fine sir.
Now it is visible, no sir?
It is visible sir.
Okay, thank you. So the first slide, structure of the presentation. Okay, hello.
Sir, tell sir.
So you can see the first slide, no? Introduction.
Yeah,
Introduction.
Yes sir.
Yes sir, done. So I can continue now sir.
Okay.
Hello?
Sir, you can continue sir.
Okay, thank you very much. Thank you for the feedback. Okay, yes. So as I was telling this, why one should know the concept of property and ownership. Here, you all know that nowadays we think about the property and all debate takes place in the society also only regarding the property. So here, the ownership and property. Now, there are a lot of difficulties in understanding this. So this IPR should also be understood in the background of this particular debate. Okay, so if you refer to the jurisprudential aspect, we divide the properties into material things Example like land, chattels. So they are categorized as a corporeal property. And then the other side, we also have immaterial things. So example is patent, copyright, trademarks, and all these kinds of property. So they are also called as incorporeal property. Okay. Now this right, what we have in these kinds of immaterial property, they are known as rights in re propria in immaterial things. Okay, under the jurisprudential understanding. Now, the subject matter of such rights, okay, is they are the immaterial products of human skill and labor. Okay, so it is purely a product of human brain. No, that is why we call in the modern law that every man owns that which he creates. So if with my brain and in thinking, if I create something, it could be a poem, or it could be a painting, or it could be a story, whatever. It all, I own that. Okay, so that is how here the human skill and labor is involved. But one more thing, that there is a principle of fixation. So it should be out in the form of material form, so that I can see the painting. I should be able to read the book like that. So here, that which he produces, it is his. So he owns that. So it is his exclusive right to use and get benefit out of it. So this is what the law protects in such type of property also. Okay. So the immaterial product of man's brain may be as valuable as his land. So now there is, nowadays what happens is someone may ask you how much land you owns, but it is more important how many patents you own, or how much IP rights you have, because that is more valuable. That day may come, that is more valuable than the such material things like land, chattels and all, corporeal property like that. Okay, so the law gives him or her such a proprietary right in such immaterial things. Okay, in such rights. So any unauthorized use of it by the other person is considered to be violation of his ownership right. Now this copyright over a literary work like poem, story, novel. So the subject matter of this right is literary expression, what we call, of thoughts or facts. Okay. So this is the subject matter of that particular copyright over the literary work. Similarly, copyright over artistic work, there it is painting, drawing, sculpture, photograph, any picture. So that becomes the subject matter of copyright over artistic work. So I can show those pictures, but due to time constraint, I may just explain. So here you should know this property and the right is used in two sense. One is concrete sense and the other one is abstract sense. So let me explain here. Concrete sense means that material, that photo, that paint and the canvas. So that is a property, the picture, the property of the picture. The person who purchases that photograph or that photo, he will become the owner over that material thing. Okay. But in the abstract sense of the artistic form made visible through that particular paint, okay, so that belongs to the author of that particular art. So this is in the abstract sense. One should know the concept of property and the right. Okay, so in the concrete sense, that property, that material property can be infringed. Right over that material property can be infringed by destroying it or by just taking away, by committing theft. Okay, but whereas this immaterial property, that copyright can be infringed by making this, photocopying of that or taking a Xerox of it. So this is how the infringement differs if you compare with material property and immaterial property. Okay. Yes. Now, similarly, copyright over musical and dramatic works can be infringed by unauthorized performance of that particular musical work or unauthorized representation without the consent of the owner of that particular work. Okay. So this is the jurisprudential base one should know. Now, generally, why such protection is given to such intellectual property by the law? The first thing you all know that we should, encourage such inventive researchers, creators who has put in his labor, time, and his capital. So he should be encouraged and he should be rewarded. Okay. And this is going to be helpful not only to that person who creates it, but also to the society at large. So there is public interest also is involved. Hence, we need a protection, strong protection of intellectual property under the legal regime. Okay, this is the justification. Now, we should also at the outset, we should refer to the debate over IPR vis-a-vis human rights. Now, why this debate is to be looked into? It is because some scholars, they treat that IPR itself is a human right. Okay. Why? Because he has put in such a effort and all, so he should own it, and it is his human right. But on the other side, there are downtrodden people, those who can't afford to purchase such thing, those who can't have an access to such knowledge or to such material, then he will face a problem, isn't it? For him, it would be his violation of human right if you don't get a access to knowledge, access to such materials. So that is another side. But nevertheless, a law needs to strike a balance between these two types of rights. Okay. Yes. Now moving further, now there is a expansion of such property rights, intellectual property rights, which cuts across the distinction between mind and matter, nature and culture, north and south. Okay. So it is because of this, it raises some philosophical as well as political issues relating to this intellectual property rights. ಈ ಬೌದ್ಧಿಕ ಹಕ್ಕುಗಳ ಬಗ್ಗೆ ಸುಮಾರು ಸಮಸ್ಯೆಗಳು ಉದ್ಭವ ಆಗ್ತಾ ಇದ್ದಾವೆ. Okay. One more development that has taken place is with the establishment of global regime for the enforcement of this intellectual property rights, a high and a uniform level of intellectual property protection has been expanded from developed to developing countries. So ಈಗ WTO ಮತ್ತು WIPO establish ಆದ ನಂತರ all the member countries should necessarily make their laws in accordance with these international developments. Andre, throughout globe, these creators of the intellectual property should have a protection. Okay. So one more trend that is happening is that all trends that have been spurred by the perception of a technology revolution, what we are seeing in information and communication technologies, because we have internet. Okay. So there is a concomitant perception of huge profits to be lost to pirates. Now, copying has become very easy. Anybody can download any material at just one click of button. So there is a possibility of video piracy. Okay. So these pirates, they would gain, and it would be a great loss to the creator. Okay. On the one side. On the other side, of course, if you provide a strong legal regime to the intellectual property, then the creator will have his gains protected. So he will be encouraged to put in his hard work in this particular field. So like this, there is on both the side, one needs to look into it. Okay. And one more thing that we should look into is that from the point of view of human rights of the others, one high-level committee, high-level expert committee in India, it had observed that, or it had asked that whether we as a human beings do not have a natural right to imitation, the right to imitate each other, right to learn from each other, and right to elaborate and develop each other's ideas and activities. So this is possible if you have some kind of exceptions also to the infringement of intellectual property rights. Hope I am audible. There was some disturbance. I can continue.
Yes, sir.
Okay.
Yes, sir.
Yes, sir.
Yes, sir.
Okay. So now let me refer to the question, what is copyright? Now, basically all, if you see any material, there is a reference to English Oxford Dictionary. What it says is, as I told in the beginning also, it is an exclusive right, a kind of monopoly given by the law, okay, for certain term of years. So for a copyright holder, it is also depends on what subject matter he's claiming a copyright. Lifespan and sex plus 60 years, like that, it differs. Okay. So here author also enjoys this right, as well as assignee. Assignee means the person to whom this right has been assigned by the author. This is a simple meaning given under that particular dictionary. Now, if you refer to the act itself, there is also an explanation given under the Indian Copyright Act. Now, just simply, I put it in a very simple term. I cannot refer to the elaborate definition there. So what it says is, it means the exclusive right to do or authorize the doing of any of the following acts, like in the case of literary, dramatic or musical work, to produce the work in any material form, like publish, print. Okay, if it is a novel or if it is any book, so he has a right to publish. Okay, he has a right to issue copies of that particular work to the public. So this right includes all these things. So it goes on elaborating all other aspects. I don't want to touch upon those aspects. Okay, this is with regard to that literary and dramatic and musical work. Okay, sound recording, playing of the drama. Okay, those kinds of things. Then in case of computer program also, there are certain rights, right to sell that software, computer programming and all. So even in the case of artistic work, so there are rights. And with regard to cinematograph film, so there is a clear explanation under that act. So production of the film and exhibiting of the movie and all. So, and even with the sound recording. So with regard to all these things, maker or a creator will have a right. So this is what the copyright is all about. Okay. Yes. Now, next question, why such copyright has to be protected? So that is a next question comes to our mind. In the earlier also, I told you the justification of IPR, no? So one reason is that creative efforts have to be rewarded. That is one. And has to be dissemination of copyrighted works that has to be encouraged for the public good. So this is a reason as to why a copyright has to be protected. Now, what are the subject matter of the copyright? Okay, so if you refer to section 13 also, there it is explained. In other words, what can be copyrighted, because anything we create cannot be copyrighted, no, isn't it? So there must be clear criteria laid down under the law itself. Okay, now the first thing what it says is, any original literary work, okay, it includes book, song lyrics, etc. So that can be copyrighted. Okay, so you know that Chetan Bhagat's book he wrote, and Sharma's The Monk Who Sold His Ferrari. These are all famous books. Okay, they have copyright over that particular material. Or take for example, any institution comes up with a research report. So it has created that report based on its research. So that institution will have a copyright over that particular report. So like that. Okay. Here also one can refer to this question paper. Normally the university will have its question papers for the purpose of conducting examinations. Okay, it could be degree examination or any kind of examination. So now the question arises whether can it be called as a literary work and can it be copyrighted? Okay, so no, there is some intellectual work has gone into it, and one can say that it can be copyrighted and it lies with the university. So like this. So or even song lyrics, the one the composer and all the lyricists, they can claim copyright. So similarly, a dramatic work can also be copyrighted. Drama performance, and those who have written dramas and all, the authors of drama, they can, because there is a his expression of thought. Okay, his sometimes it could be a expression of facts also, or his ideas also. So he has dramatized it. Maybe he had depicted some social issues or what is going on in the country. How he may write about this COVID-19 situation, how society has responded to this COVID-19 or lockdown situation. If he makes a write-up on that, and he can claim a copyright over that. Okay, this is both literary and dramatic work. So similarly, we have a musical work. Okay, A.R. Rahman and so many other such people, they have their own musical work they have created. So they can also ask for copyright. Okay, so please remember that it is the music and the graphical notation that is entitled to get a protection, and not there the words and the action, dance that may be shown. Okay, there may be a music behind it, and the words or the song being sung, or the dance that is being performed on the stage, that cannot claim under this head. Okay, so only the music that can get protection under this particular heading. Okay, so similarly, we have artistic works can also be subject matter, like any painting. There are so many famous painters. Okay, Ravi Varma's paintings and all, Hussein's drawing and all. Okay, even engineer's plan action. It could be city plan, building plan, that can be copyrighted. Maps, any map can be copyrighted. Charts that are used normally in the laboratory or any kind of research purpose. If a chart is created, that can also be subject to, it can get a copyright protection. So similarly, as I told you in the beginning, cinematograph films is also entitled to get such copyright protection under the law. So here the author, there again, the producer and the director, so there are controversies there. Okay, so they can also ask for copyright. So sound recordings and computer programs, this have, okay, there here, but in the cinematograph films, there should be a visual recording along with sound recording. Okay, and even video films. Okay, and you may ask, you may create your own video and upload on YouTube. So you have created your own video, and if you upload it on a YouTube, so whether you can get a copyright over that particular video that you have created. Yes, the answer is yes. So like that, okay, the creator. And similarly, sound recordings, it should be a recording of sounds from which such sounds may be produced. Okay, regardless of the medium, it should be recorded and it can be produced. tape recorder or anything, recorders can be used. Okay. And similarly, we have under this computer programs, particularly nowadays, this computer software, what we have, this computer software, it includes program manuals, punched cards, or it could be discs, okay, magnetic tapes, computer printouts, computer programs, all come under this computer program. Now, actually, the law, what it says is codes or schemes or any other form which a machine readable medium code is used, no, that machine reads that, and it is capable of causing a computer to perform a particular task or achieve a particular result. So if you command the computer, it will perform that particular task, or it will give a particular result using that particular code or scheme that has been incorporated into that computer. So like that, that can be a subject matter of copyright. Yes. Now, regarding the question as to what cannot be copyrighted, that is also important. First of all, you should know idea. You may have number of ideas, but all ideas, or for that matter, any idea, will not be entitled to get copyright protection. So it cannot be copyrighted. Okay. Even methods or systems, scientific or technical methods, formulas, algorithms, they are all not entitled to copyright protection. Okay. And this is first category. And the second is commonly known information. Okay. For example, we all know the calendars, standard calendars, that cannot be copyrighted. Height and weight measures, charts, telephone directories. Okay. And even the common sense knowledge like earth is round, sky is blue. So these things are not copyrighted. Okay. That is a common knowledge. Yes. Common information. Then the third is choreographic works. So in this, this is not subject to copyright protection unless it has been videotaped, noted. Okay, so unless that is done, originally it cannot have a protection. So it also applies to speeches that have not been transcribed before or after they are given, as well as any other types of performance. Okay, so the speeches given, but that could be transcribed or it should be given in the public. So then only it can get a protection. Yes, and similarly, names, okay, titles, short phrases, expressions, any name, my Rajendra. So I cannot copyright this name Rajendra. Okay. So title also, short phrases also. Okay. Here, but in case of the business, we have Tata, Birla. We have such names to the business. There, it can get a protection under the trademark. Trademark protection is there, but not under the copyright. Okay. But to this, regarding receipts also, food receipt and all, it also is not entitled to copyright protection. But if these receipts are, when they are compiled in a book, cookbook, for instance, then that receipt can be, copyrighted, provided there is some kind of substantial explanation in that cookbook. So sometimes, we find books in the market. Women, sometimes they refer to such books and prepare a new dish. So that book can be copyrighted because there is an expression. There is an explanation of their ideas and their thoughts. Okay. Yeah. And similarly, fashion, like a shirt, dress, other articles. So articles of clothing, they are not protected. But however, if a specific fabric is used on a particular cloth, then that can be copyrighted. Okay, designs of that particular fabric can be copyrighted. So these are the few things which cannot be copyrighted. Yes. So you should know that copyright law protects only the expressions of ideas and not the ideas themselves. Okay. And this copyright in form or expression, only it is in the form or expression, it is not in idea. So that one thing you should keep in mind. And even a Gregory committee also observed that there is nothing in the notion of copyright to prevent a second person from producing an identical result. Okay, because if he has got his independent expression, independent showing of it, then there is no infringement of copyright. Okay, so as I told you, this principle of fixation, so that expression should be in any material form. That is what. Okay. Yes. Now coming to the nature of this particular copyright, which has been explained in the law itself. The first thing that you should know is it refers to bundle of exclusive rights. As I told you in the beginning also, that right to produce, right to disseminate, right to sell, right to give to the public, all those kinds of rights are there, vested in the owner of a copyright. Right. Now, it is also known as right in rem. There are two types of rights under the law, right in rem and right in personam. Right in rem means right against the entire world. I can claim this right against the entire world. But whereas right in personam means it is only with, suppose if I entered into a contract with another person, then I can have a right only with regard to that another person, right in personam. Okay, but here this copyright is falling under the category of right in rem. So you can exercise this right against the entire world. So it is both positive and a negative right. Why it is so? Because positively it protects the interest of the author, but negative means it prevents the others not using the property of this copyright holder without his consent or without his authorization. So unauthorized use is prevented. So that is why it is also a negative right. Okay, so you know that it is a product of labor, skill, and capital. So all are involved. And one more different dimension of this is that this copyright is also a right to control certain types of information. This is most important. This is also a new dimension that one can have. So this is also used to control certain types of information if they are harmful to the society and those kinds of things. So how the reader pursues it on those aspects. Okay, then copyrighted works, they contain unique communicative properties. Okay, because it has both expression and understanding of that expression. So there is a kind of memory is involved, attention is involved, and the reader's preference is involved. So cognitive abilities are involved in this right, okay, copyright. Hence, the courts should frame the rules by providing better balance between rights of the owners as well as need for open engagement with expressive works. Now, as I was earlier telling that there is a secondary right. Okay, so the reader, what he pursues it. So from that angle also, it should be looked into. And as well as the debate from a question of what owners deserve to look at, what audience require in choosing and consuming such works. So that also one should look into in understanding the nature of copyright. Okay, so there ends that particular explanation of nature of the copyright. Yes, now moving on to the what are the objectives of this particular act or this particular law. First and the foremost is that to encourage, to create this creative work, basically. So unless I am recognized and I am given reward, I will not create anything just for the pleasure's sake, isn't it? That's human nature. So that is a reason why law should give protection, and that is one of the objectives. And basically, this creative work is disseminated for the benefit of public. One, and the second is it also promotes the progress of useful arts and even science, and for that matter, such knowledge, by protecting the exclusive right of the authors and the inventors to benefit from their particular works. Okay, and then negative aspect is to stop the misuse of copyright, negative aspect, and to provide also remedies in case of infringement. Okay, yes. So along with that, there can be other objectives also. Nowadays, even it protects the performers' rights, okay, like other neighboring rights, and those kinds of newly added objectives are there in the Act based on the developments that are taking place at the international level. Okay. Now, moving to the next question, whether copyright registration is compulsory. So that is a very frequently asked question. So first, let me tell you that it is optional, right? Why it is optional? Because some may not prefer to go for this procedure. They may just create it and just enjoy. And please remember, in the eye of law, the moment a work is created, he gets a copyright over it, immaterial of the fact that whether he has registered or not. So that is what you should know. But from the, as a lawyer, or from the point of view of the and a good advisor, it is advisable to obtain a registration, okay, because of the better protection. Suppose if there were to be future disputes over that copyright, sometimes if money is involved, if a lot of claims are involved, then definitely it is the registration certificate that will help the author. Otherwise, he will land in trouble. Okay, so this is how. And please remember that this registration, prima facie, it does not confer any kind of right there. It only gives an evidence. It has only an evidential value. Okay, that you should remember, right? And it also helps the author to take legal action against the infringer, right? And so in case of receiving the royalty also, whenever there are disputes, then he can show this certificate of registration for claiming the royalty, all those kinds of things. And one more is that by registering in one country, he will get protection in all the other countries also, if they are a member of that particular members of that Berne Convention. Okay, so this is a very good advantage. So you need not go to each and every country to get a protection. Even if you register under the Indian system, then you will have a protection in the other members of the Berne Convention. So that is another advantage. And one more advantage is India can also, by virtue of issuing orders under the International Copyright Order, it can extend copyright protection to works first published outside India. Okay, if he is an Indian, if he resides in a foreign country, to him also a protection can be granted. Okay. Then actually the registration is a simple procedure, and but there are again some problems with the delay and some red tapeism and all those kinds of things are there. So that will be natural. Then the next question is, who is the first owner of this particular right? So it is normally common sense. It is the author or the creator of that particular work is the first owner. But to this rule, there is an exception. Suppose, an employee who is working under the contract of service, right? And while working under that employment, if he creates something, then it is the employer who becomes the first owner and not the one who has created actually, because he is being paid for creating that. So it is a kind of, he is only a servant. No, so the first owner goes to the owner, that is the employer there. Okay. And one more interesting is that in case of any speech or any address delivered in the public. See, in that, the person who delivers such speech, he becomes the first owner. Okay, there is also an interesting point that if a person has delivered a speech on behalf of any other person, then it is such other person shall be the first owner of the copyright therein. Right. Okay. But of course, there are other exceptions like the government. If suppose under a government, something is created, the government employee under his employment, if he creates some report or if he makes certain plans and all, then in that case, it is a sovereign function, it is the government work. Hence, the first owner, it is the government becomes the first owner of that particular plan because it is the government work. Okay. Yes. So that is regarding the ownership. Then regarding assignment, there are certain rules. Now, the basic question that comes is whether it can be assigned or not. Definitely yes. An author can assign to whomsoever he wants under a particular contract or an agreement. For assigning his right, he gets in return, in consideration, some amount of money. Okay. So here, while assigning, he may assign all the rights or only few rights, or for some limited period or for the entire period. Okay, so it varies. And also there is a possibility of writing a will also. By writing a will, the author can assign his copyright under the will. So after his death, it will go to the legatee, okay, the person in whose favor it is written. But the one important thing under the law is that to make this assignment of copyright valid, it should be in written form. Okay. So even sometimes manuscripts, copyright over the manuscripts can also be assigned. Here, Dara Bendre's manuscripts were assigned to his legal heirs or to the trust or something like that, Bendre Trust. So those kinds of things. Assignment can take Sivaram Karant's some works. Okay. So this assignment is possible. Yes. Now coming to the protection of the particular this right. Now we have two types of forms in which it can be protected. One is economic rights of the author, and the second one is a moral right of the author. Okay. Now economic rights means just by assigning you get royalty. That is your economic right. By issuing copies or by performing that drama or exhibiting the movie in public. Okay, so those kinds of things, or by playing the sound, recorded sounds, all those kinds of things. So that is an economic right, and that is protected under section 14. Okay, so he can sell, and even for resale also he receives the royalty. Okay, so that also becomes a part of the economic right. Okay, so once the published work is completed, it goes for a second publication or reprint and all. There also he gets the share in the resale. So that is economic right aspect. Then regarding this moral rights, which is very much important with regard to this Three Idiot movie. So the Amir Khan's Three Idiot movie, a very famous movie. All of you must have seen that movie. Now there, what was the controversy actually? You must have read in the newspaper also. Here, you must have also heard about Chetan Bhagat, whose book, 5 Point Someone. Okay, that was a book. And here, he actually, there was a contract also under that he received some amount, okay, for using that novel in producing that, in making that movie. So what has happened is his name was not shown in the first itself. It was shown, it seems, in the at the end of the movie. Okay, so he had some allegations regarding that. So what he says is, when you have made a movie based on my novel, you should give acknowledgement to me. You should recognize my contribution in the beginning itself. So by not recognizing in this way, you have violated my moral right. So my moral personality. So in this moral right, we have right of paternity, that is authorship, one aspect. That is right of attribution. You attribute that movie to Chetan Bhagat. Okay, this is one aspect. The second one is right of integrity. Right of integrity means Chetan Bhagat has got his own reputation. He has his own personality. Okay. By mutilating or by distorting or by altering, if you show the movie, then it will affect the reputation of that author. So here right of integrity is going to be affected because it is going to prejudicially affect his honor, isn't it? So that is right of integrity is also part of this moral rights. And the third one is right of divulsion. It is nothing but when it is to be shown, circumstances in which this work has to be first presented to the public. That also becomes very important. Of course, in that 3 Idiot movie, out of court, it was settled, and later on, that was not litigated at all. That is a different story. But it gave us an opportunity to look into this aspects of moral right. Actually, we have two types of countries who treat this moral right. One, common law countries like US and all, they give importance to economic rights, right? Whereas some civil laws nations like France, Germany, they give importance to the moral rights, which are considered to be inalienable rights. Okay, so theoretically, these moral rights elevate the artistic personality over the proprietary right. So it is the personality that becomes more important than the property. So that is the emphasis of moral right. Okay, so this 3 Idiot movies, this I have already explained to you. Okay, and later on here the debate that followed after this particular controversy is that should the Indian law be amended to incorporate this? Yes, it was done after 1994 amendment. Okay, and there what had happened is even at the international level also, WIPO finalized two important treaties. One is uh, WIPO Copyright Treaty, and the other one is WIPO Performances and Phonograms Treaty. Okay, so like this. And now what has become important is that moral right aspect can be abused also. That is another problem. Now, sometimes what happens, suppose in this 3 Idiot movie itself, if you take, so whatever the fee he receives as an author might be very less. But if he files a case and wins in the court for mutilating his work, for distorting his work, then that is what is known as damages award, compensation award, damages award. That can be more. So the law needs to balance in giving protection to this moral right. Okay, so that is the reason why in the law there is some kind of middle way approach has been adopted. Similarly, some cases like Eastern Book Company versus Navin, in that the question was if the judgments of the courts were reported in a book, can it be copyrighted? Now, please remember that if it is a government order or court's order as it is, then it cannot be copyrighted. But if it is compiled and it is read and it is some commentary is given, subhead noting is given, then it can be copyrighted. So like that. Okay. Similarly, we have Prakash Punit Prashant case, wherein a High Court held that even if the title of the book is changed by adding a word, then that amounts to infringement of copyright. Similarly, in Ushodaya Enterprises case, the Andhra Pradesh High Court held that the curtains that were prepared and some artistic work made on the curtains. Now here, curtain can be registered under trademark, but artistic work made on that curtain can be copyrighted. So without his consent, if you use for the other material, then it amounts to infringement of the copyright. And we also know this Pulan Devi's case, Shekhar Kapoor, Bandit Queen movie. So it was based on the Pulan Devi's life. So she has also litigated that based on the violation of copyright. If suppose Pulan Devi's life is depicted in a way which is harmful to her reputation, then it affects the her right also. Okay. So coming to the academic institutions, we all know that even UGC regulations are also there. Nowadays, promotion, appointment is done based on the number of publications. So because of this pressure, we are finding academic dishonesty and copyright infringement is rising. Okay. And this has become easy because internet and all, isn't it? So for this, what needs to be done is we need to understand these policy relating to plagiarism and copyright properly, so that we can avoid any legal consequences or legal actions. Okay. Take for example, even if you send any copyrighted material to other person through email, okay, without the permission, then it could be infringement of copyright. So like this, even simple act can land you in trouble. Okay. Hence, more kind of surveillance mechanisms are required to protect such kind of things. Okay. And students need to be brought awareness about this. Researchers need to be brought awareness about this. Okay. Yes. What is the remedy is you should focus on the quality of publications rather than the number of publications. Okay. Yes. Now here I have already told you when it amounts to infringement actually under the law. So if you exercise the right of the owner by making or distributing or photocopying or playing the movie, okay, so like that. So here a very difficult problem is when exactly the copying happens. So whether this copying, is it an infringement? So it is basically a question of fact and law, right? Hence, in any enactment, the term copying has not been defined, because each and every case has to be decided based on the that particular facts involved in that case. Okay. So there has to be a proper assessment, and normally if the matter reaches the court, it is the court which is a proper authority to make an assessment whether there is a real copying or not. Now, one should read this Barbara Taylor Bradford versus Sahara Media Entertainment Limited. It's a very interesting case wherein that TV serial was shown, first episode was shown, and the producer and the maker of that serial had given an interview to one magazine and to one journalist. And in that he had admitted he made this a TV serial based on a particular novel written by one author. So there was a controversy as to whether the copyright of the author is infringed by exhibiting that particular TV serial. So there was a lot of discussion. When can you say that it is copied substantially and fundamentally? So those aspects has to be looked into. So here what you need to look into is theme and the plot. Theme may be adopted, okay, or it may be based on a particular theme. But if it is expressed or if it is shown in episode in a different way, I mean, based on his own creative work, then that does not amount to infringement. Okay. So only because he has referred to a particular theme, based his TV serial on a particular theme, that does not amount to infringement. Okay. So this is all about the infringement. And there are exceptions to this infringement also. One is fair use. If you are using these works fairly for the research purpose or for progress of the art, then it is not infringement. Okay. And if you are for the purpose of making criticism, constructive criticism, which is very much required for a democratic country, so that is also not infringement. And particularly computer programs that needs to be there for interoperability. So these programs have to be there. But of course, if you have a legal version of that computer software, then you can make a double copy of that. So there is no issue because of the, you should run that particular system. And similarly, for the purpose of reporting the current events, okay, reading and reciting certain paragraphs in the public, in a particular dramatic work, and for the educational purposes, teacher uses a particular paragraph for the purpose of educating the children and even question papers, so they will not amount to infringement. Similarly, here in the public library, okay, taking a photocopy of the book, if that book is not available, and if you are using that photocopied book for your private use, for your research purpose, of course, copies, public librarian may allow you to get a photocopy of that book, but it should be it should not be more than 2 or 3, something like that. So if for these purposes, if you are going to use this copyrighted material, then it does not amount to infringement. And finally, coming to the remedies, under the law, we have, of course, 3 types of remedies: civil remedy, criminal remedy, and the administrative remedy, like that. Under the civil remedy, important, we have interlocutory injunctions, stay order, which is normally claimed because it gives immediate relief. Okay, so but to get an interlocutory order or stay order, you should prove 3 things. One is there is a prima facie case in your favor. Second is balance of convenience is in your favor, and the third one is if it is not stayed, then it would cause irreparable injury. So this is what injunctions. And the second one is pecuniary remedies, like compensatory damages can be claimed. Okay, and accounts of profits which have to be looked into. Okay, which is earned by the other person. Then the conversion of damages which are assessed according to the value of the article. So that is a pecuniary remedy. And we also have other types of orders. We need not go into that. Then criminal remedies, like criminal case is proceeded, is initiated, then it may lead up to imprisonment up to 3 years, but not less than 6 months. And even there can be penalty imposed, not less than 50,000. It may go even up to the extent of 2 lakhs. There can be seize and search order for the infringing goods. Okay, and even for the delivering of infringing goods to the copyright owner. So these are remedies available under the criminal head. Okay, now coming to the conclusion, by overall looking into this, of course, there are different terms that I referred for the copyright owner, depends on the type of work he is claiming. Okay, so for a literary work, it is life plus 60 years. Okay, such a long duration is given. And even the copyright can be claimed regarding unpublished works also. If the person is dead, any person interested, can ask for that. And okay, so those kinds of things. Yes, so overall, by looking at the law and the present scenario, what one can say is law enforcement machinery should be strengthened, because we are finding nowadays a lot of piracy problem. A lot of, the moment a new movie is released, we get pirated CDs. A new book is released, we get some pirated books also. So those kinds of things. And this is happening because enforcement machinery is weak. That is one. And as far as registration is concerned, there is a delay. A lot of problem is there with the offices, and these offices need to be strengthened. And one more is more awareness. Such kind of programs need to be conducted, and it should be introduced at the lower level, even at the institutions, so that students can, prevent their future problems relating to plagiarism. And law should be amended to cope up with the changing things that are happening in the field of ICT, including the artificial intelligence and all. Okay, law is sometimes considered to be very slow as compared to the technology. So it has got a both role to play. Okay, but somehow it should not be a mere spectator for the things that are happening in the society. Okay, so with this, I think I have given only some basics about this. it is not possible to cover the entire aspects like broadcasters' rights, performers' rights, and the copyright board, register of copyright, and those kinds of things are there in the act. And there are notifications also, and there are a number of case laws also, but time will not permit me to refer all those kinds of things. I should thank the organizers. I think I should thank the Swamiji, the CEO, secretary, principal, coordinators, and all the participants for having a lesson, patience listening. Okay, thank you, one and all. Sir.
Thank you, sir. Thank you, sir. Thank you, sir. Thank you, sir.
Thank you, sir. Thank you.
Vasanara, conclude ಮಾಡೋಣ. Sir.
Sir.
We are grateful to you, sir, on behalf of our institution, and I individually also I am very grateful to you, sir, for being with us and delivered a experienced talk on the today's topic. You have given a justice on the topic, sir. Really, all the participants are very happy. I am receiving some messages in this message box, sir. It is a wonderful session and a knowledgeful talk also. So once again, I am very thankful. I'm very grateful to you, Rajendra Kumar Hittingi, sir, on behalf of our institution. Thank you, sir. Thank you, sir.
Thank you very much, sir. Thank you very much, sir. Thank you. So, shall I leave the meeting, sir?
Yes, sir. Yes, sir. Yes, sir.
Okay. Thanks.
I am very much grateful to our Swamiji, who has blessed us to make this success, make success this webinar. And I am also very grateful to our secretary, Sri A.G. Paramshivaya, and our CEO, Sri A.G. Doreswamy, sir. Also, I am very grateful. And I am very thankful to the yesterday's resource person, Dr. Sunil Bagade, sir, and tomorrow's resource person, Karyana, sir, and also Matoli, sir, and Professor Dinesh, sir, who were being with us. So I am very thankful to all the resource persons. And once again, I am very thankful to all the participants who are being with us since from 4 days. And I am very thankful to Professor J.N. Basurajappa, who carried over this webinar throughout the week. Once again, I am very thankful to him also. Sir, I am grateful to all the participants from the Karnataka and out of the state. Some guys are joined from the out of the states, from Jalandhar and from Agra and from Kakatiya University, Warangal, and Yashwantrao Chavan Law College from Pune, and some Srinivas from Goa, and Varanasi also, from Ranchi also. So from all the corner of the nation, some guys are joined to make success this webinar. I am also thankful to that guys also on behalf of our institution. Thank you, sir. Thank you, one and all.
Thank you, sir.
Thank you.
Thank you. Thank you.
Sir Basurajap, sir, please announce tomorrow's resource person, sir.
ಸ್ನೇಹಿತರೆ,
Tomorrow program, please announce, sir.
ನಾಳೆ ಡಾಕ್ಟರ್ ಕರಿಯಣ್ಣ KS ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು ಸ್ವತಿ ಕಾನೂನು ಕಾಲೇಜು ಚಿತ್ರದುರ್ಗ ಇವರು ಲಾ ರಿಲೇಟಿಂಗ್ ಟು ಟ್ರೇಡ್ಮಾರ್ಕ್ಸ್ ಇನ್ ಇಂಡಿಯಾ ಈ ವಿಷಯ ಕುರಿತು ನಮ್ಮ ಜೊತೆ ನಾಳೆ ಮಾತನಾಡಲಿದ್ದಾರೆ. ನಾವೆಲ್ಲರೂ ಕೂಡ ನಾಳೆ 11 ಗಂಟೆಗೆ ಸರಿಯಾಗಿ ಮತ್ತೊಮ್ಮೆ ಸೇರೋಣ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತಾ, ನಮ್ಮೆಲ್ಲರಿಗೂ ಕೂಡ ಮಹಾವಿದ್ಯಾಲಯದ ಪರವಾಗಿ ವೈಯಕ್ತಿಕವಾಗಿ ಹೃತ್ಪೂರ್ವಕವಾದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತೇನೆ. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್
ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು.